Back once again, our Neville, Beard and Arsenault Legal Difference segment continues today with Mike Koch now with us. We're going to continue to talk about the litigation. This is a topic that we've been on for a long time. Interesting topic to see how things operate in the courtroom.
And today I believe we're going to talk about objections, Mark.
Okay.
So you want me to tell you a little bit about objections? What objections are is that's something that the lawyer does during the legal proceeding. And what he does is based on the evidence that's being presented at the time. It could be an exhibit, it could be a witness, and you make the objection. At that point, the other side is going to respond to the objection, but then the judge gets to make the final decision on your objection.
Who can make an objection? You were talking about, explain that a little bit.
Yeah, both sides make objections, and the thing about objections too is that it's something you can do before you get to court too. It's really important to do that. Good lawyers make good objections. It's really, and that's based on knowing the law, knowing the evidence, and then knowing and anticipating what the evidence is going to be. So what we do is in jury trials, we file motions in limine, which we set forth the objections to the evidence we anticipate coming in. So in other words, it gives a chance for the judge to rule on a matter, to do the research, and to put a lot of thought and time into it before it comes up instantaneously at trial.
You got to be quick on your feet.
You really got to be quick on your feet, absolutely. And you got to know the law and know the objections.
And you got to do your research beforehand, I would think. Be really prepared, or at least feel like you're really prepared when you get to the courtroom.
And absolutely. And that's what makes a good lawyer. I tell everybody. I tell the young people that. The good lawyer is the prepared lawyer. And if you're prepared, you're willing to handle anything that comes your way. But the key to it is being prepared before trial. And a lot of times our clients who are not familiar with the system and who see court cases on TV think the lawyer should be jumping up the whole time and then arguing with the court, arguing with the defense counsel, and then that's going to make their case better. But unfortunately, it doesn't work like that.
A lot of drama, you see on TV, but it's not like that in reality.
It's not. No. And unfortunately, they don't know because they don't really see the real courtroom. And to be honest with you, a lot of times it could be considered boring. It's just methodical questioning. And then they want you to object, and you're like, no, that's not the proper thing to do at this time. Just because they hear something they don't want to hear, and I understand that, that we should object to it, but that's not the case. It needs to be a proper objection based on the foundation of evidence.
All right. What can you object to?
There's a lot of different things, like relevancy is a big thing. Cumulative, if you already asked the question once, you object, to that. Subsequent remedial measures, that if somebody does something after an accident, you can exclude that. Accident reports don't automatically come in. You object to that. So there's a lot of different types of objections, that come up. And then we also do it in what's called written discovery. We make objections when they start asking, like harassment. They want to start asking you things that they're not entitled to ask you about. It's not like they have open range on the questions they can ask you. So we object to it to make sure they keep it in line. They're not harassing, the client or witness. So that's probably the most important thing. And then relevancy. You can't just go off and ask any question.
You got to be relevant
to the topic at issue.
The case. Why are objections so important? Why do you think they're so important in the courtroom?
Well, because they can win or lose a case. Obviously they can win or lose a case. They're incredibly important, and that's why a good lawyer knows the objection and knows when to object.
I think that would be important when you actually know when to object.
It is, and a lot of times during jury trials, like when they do an opening statement, do you object then? That's part of experienced lawyer, when to object. Are you going to get the judge mad? Does it matter to the judge? Does it not? Are you going to get the jury mad? So those are little things, it's constantly in your mind that you're working to decide when you object and how you object and how often you object.
A lot of that you learn through experience.
Exactly. That's what it is courtroom experience.
It's interesting stuff, talking more and more about litigation. I feel like I'm learning a lot about what goes on in the courtroom.
Right, exactly.
All right, Mike, the best way to get in touch with you, Neville, Beard and Arsenault?
Neville, Beard and Arsenault is the best way to get in touch with us. And then so. Right.
All right, be good. Saints LSU, you've been taking your kids to the Saints LSU games a lot, we were talking.
I have been, and that's really been a thrill. We've had a great little run lately on both the Saints and LSU.
Both of them playing really well. So it's a lot of fun.
It is. It is. It's been a thrill to watch them. We even had a chance to go to the Vanderbilt game with the boys, and that was just a super game. Then they came back last week against Florida and just played lights out.
Going to go to Tuscaloosa for the big game with Bama?
You know, we're still debating about the tickets are too doggone expensive.
I know, they really are expensive.
Right.
All right, Mike, good talking to you.
You too, Mark. Thank you.
More to come.